Good afternoon, everybody. Welcome to this UCL Lunch Hour lecture on lawyers and acting in the best interests of clients. My name is Anna Donovan, Associate Professor of Corporate Law here at University College London and Director of the UCL Centre for Ethics and Law. It is my honour and pleasure to introduce today's speaker and a colleague of mine at the Centre for Ethics and Law, Professor Stephen Mayson. Stephen Mayson was called to the bar by Lincoln's Inn, of which he is now a bencher and chair of its regulatory panel. After a period as a tax lawyer with a city law firm, he developed an international reputation as a strategic advisor in the legal sector, working on a range of strategic, financial, ownership, and governance issues with law firms and corporate and government legal departments. More recently, he has held a number of non-executive directorships and retained strategic advisory relationships with law firms and law-related businesses. He is also currently non-executive chairman of an ABS law firm. Since 1992, Stephen has held professorships in the UK and abroad, and is presently Honorary Professor of Law at University College London, attached to the Centre for Ethics and Law and the Centre for Access to Justice. He has a particular interest in the regulation of legal services and conducted an independent review of the regulatory framework in England and Wales from 2018, submitting his main report to the Lord Chancellor in June 2020. This was followed in 2022 and 2024 by supplementary reports on consumer harm and the public interest. Stephen was subsequently appointed by the Lord Chancellor to the expert panel supporting Sir Christopher Bellamy's review of criminal legal aid, and has recently served on the task force established by the Institute of Business Ethics to examine business ethics and the legal profession. Before we begin, I wanted to let you know that we will have some time at the end for questions. These can be submitted via Slido. So if you just go to Slido in your internet browser, that's sli.do, and enter the event code #interests, you can submit your questions then throughout today's proceedings. On that, I'm now delighted to hand over to Stephen for his talk.
Thank you, Anna, and a warm welcome to everyone from me. Thank you for joining us today. In recent years, there have been several instances of lawyers who've sought to justify certain actions they've taken as matters of professional ethics. In the eyes of some, these actions have been of dubious moral or ethical merit. For example, they've included lawyers asking individuals to sign non-disclosure agreements, as in the Harvey Weinstein cases, or threatening them with defamation claims. The intention too often is to prevent certain unpleasant facts being made public, or even to hide possibly criminal behaviour. The examples have also included withholding helpful evidence from other parties in litigation, as in the Post Office Horizon cases. In the eyes of the lawyers involved, these actions are justified as being part of their professional obligation to act in the best interests of their clients. So as Anna said, in 2018, I began an independent review of legal services regulation carried out from the Centre for Ethics and Law here at UCL. By September 2024, I'd published 3 reports, and the third focused on the obligation of lawyers to act in the public interest. This immediately sets up a possible tension between serving the best interests of clients and acting in the public interest. Most people accept that law is a profession, and they do expect members of the profession to serve them faithfully. But in these reports, I went further. For today's purposes, I can summarise my view by saying that I claim that lawyers are part of a public profession. By this, I mean that the status and licence to practice as lawyers is given on behalf of the public. Lawyers are then given a degree of monopoly over the provision of legal services, as well as some control over how they provide their services. So in return, I say that they owe a reciprocal obligation to the public, which means that when acting for their clients, lawyers owe a duty to act for the greater good and not only in their clients' interests. Clearly then, my position that lawyers owe a higher duty to the public interest can lead to a conflict if a lawyer believes that they must act primarily in their client's best interests. My purpose in this lecture is therefore to explore how the duty to act in a client's best interests might be reconciled with a higher duty to act in the public interest. Just some initial background comments before I get on to the substance of the lecture. First, the concept of best interests is a little like Doctor Who's TARDIS. From the outside, the duty looks well contained, but once you get into it, it becomes a much bigger, multi-dimensional journey through time and space. Therefore, I'm afraid that this lecture can only scratch the surface. It's work in progress, and I hope to publish a more detailed working paper shortly. Second, I also need to say that I'm focusing only on England and Wales. There are different laws and regulations in place relating to lawyers in Scotland and in Northern Ireland. Third, I'm also talking mainly about solicitors, and often using that title interchangeably with lawyers. This is primarily because solicitors represent by far the largest proportion of the regulated legal sector, and most of the situations and examples that I refer to relate to solicitors. And finally, the regulatory framework is complex and fragmented. Looking at the two main legal professions of solicitors and barristers, the historical position of self-regulation by the professional bodies, the Law Society and the Bar Council, was replaced by the Legal Services Act 2007. There's now a requirement for the delegation of regulatory responsibilities to dedicated regulators, the Solicitors Regulation Authority and the Bar Standards Board. This leaves the Law Society and the Bar Council essentially as representative bodies, in a sense, the profession's trade unions. There are 7 other professions within this framework, but all are overseen by the Legal Services Board. Professional misconduct is dealt with by separate disciplinary tribunals, and unresolved complaints by clients about the service they've received can be referred to the Legal Ombudsman for resolution and redress. So let's turn to the substance. Perhaps the obvious starting point needs to be this. Where there is a duty to act in the client's best interests, do we first of all understand who that client is? According to the Code of Conduct for Solicitors, client means the person for whom the solicitor acts. Perhaps no surprise there, but it can also include prospective clients and former clients. So it might be tempting to assume that the answer to the question, who is the client, is obvious and straightforward. And in many cases, it will be. So I don't wish to make this question a major part of the lecture. But consider for a moment the situation where someone exists physically, but not capably. This could be because of a physical or mental disability that prevents an individual from being able to express any of their intentions or interests, or to do so only in a limited way. In these circumstances, the identity of the individual might be clear, but they need someone else to decide and speak for them. And so, who is the lawyer's client? Next, consider those situations where the solicitor is dealing with someone who exists as a legal entity, but not physically. This could apply, for example, to a company, a charity, a local authority, or a trust. Certain individuals must again be taken to decide and speak for the entity, but here it's still the entity that is technically the lawyer's client, and not the individuals who speak for it. Question can also become acute when we look at the position of in-house lawyers. They're employed by an organisation and are expected to be loyal employees. But as solicitors, they still have duties to act independently and to discharge obligations to the court and to their profession. And they must do this in relation to an organisation that pays their salaries and holds the key to their career progression. So it's easy to say that the employer is the client, but there may also be personal or other organisational factors at play here that are difficult to ignore or to put to the back of one's mind. So, who is the client is an important prior question. A lawyer can't be confident about representing someone's best interests if they're not clear in the first place about who that someone is. There's much more that could be said about this issue, but it's not the focus of my attention today. So let me just dangle these examples to show why it's not always as straightforward as many might think. So let's assume then that we can be clear about who the client is and turn to the consequential question of acting in their best interests. The requirement to do this arises from the overarching Act of Parliament that applies to legal services regulation, the Legal Services Act 2007. This requires that those lawyers who are authorised to offer their services to the public should act in the best interests of their clients. As I've already said, there have been instances where lawyers have used this duty as a shield to justify professional actions that have subsequently attracted adverse comment. For example, in giving evidence to the Post Office inquiry, one of the external lawyers advising the Post Office said, "In an adversarial system, it is my absolute duty to act in their best interest." And this is not an isolated view. But can it be right that it's an absolute duty? I don't think so. The emergence of such an understanding, or as I would have it, misunderstanding, might be characterized as a consequence of the idea of client-centered lawyering, or the duty of zealous representation. Many lawyers and clients might regard such an approach as no bad thing, but there's undoubtedly a dark side. The pursuit of a client's stated interests or objectives in a client-centered way can crowd out any consideration of other perspectives and interests. Indeed, the very idea of zealous representation usually will exclude any other considerations. But this approach to client representation can then allow a degree of moral or ethical distancing by the lawyer, who might say, "I don't like the client or agree with their views, but they are entitled to independent legal advice. I've offered that advice, and they're also entitled to come to their own conclusions about it. As their lawyer, I must then carry their instructions through, whether I personally agree with them or not." Such a view expresses what is often referred to as the standard conception of the legal profession, emphasising both the lawyer's independence from clients as well as the robust pursuit of their interests. For my purposes today, it's this second element of zealous representation that most concerns me. If this is interpreted to mean that as a lawyer, I must and can with impunity do whatever the client wants or asks of me, then I believe that we're in trouble, both within the profession, but more importantly, also within society. Fortunately for me, there is an alternative to this absolutist view. This would suggest that lawyers should, of course, definitely pursue those interests of clients that are given or protected by law, and certainly bring to bear all of their professional skills to secure the client's legal rights. But they're under no professional obligation to pursue anything else which happens to be in the client's interests, where that goes beyond the law or the wider public interest. In other words, lawyers should be mindful of wider interests and should not zealously pursue only those interests that the client cherishes. This was covered in detail in my 2024 report, and the foundation of this alternative view lies in the law being a public profession. This alternative view places an emphasis on public service and the public interest that is echoed in the Legal Services Act. The Act does have a professional principle that requires lawyers to act in the best interests of their clients, and therefore not in their own self-interest. But it also refers to protecting and promoting the public interest, to protecting and promoting the interests of consumers, as well as to the duty to the court to maintain the rule of law and act with independence in the interests of justice. And all of these are in addition to a solicitor's duty to maintain public trust and confidence in the profession. There are therefore a multiplicity of interests that are relevant to the framework of legal services regulation and the ethical behaviour of lawyers. Such a variety of interests could, of course, give rise to conflicts among them. However, the Legal Services Board, as the oversight regulator, has been clear that the duty to protect and promote the public interest actively requires the board to place it higher than sectional interests of particular consumers or professional interests. In addition, the Solicitors Regulation Authority is also clear that where any of its principles relating to the fundamental ethical behaviour of solicitors come into conflict with each other, those which safeguard the wider public interest take precedence over an individual client's interests. So it's clear that the best interests duty to clients is, in the eyes of regulators, subordinate to the higher duties owed to the public in the rule of law. I have to conclude that in no sense can the duty to act in a client's best interests be absolute. It's one of a number of duties and obligations on lawyers, and it isn't regarded as the highest of those duties. An absolutist view is also inconsistent with lawyers being members of a public profession who must not act in the exclusive interests of their clients. In short, the duty to act in the best interests of a client is a relative duty, not an absolute one. So with that established, the next question is how the best interests duty sits within that wider context. My starting point here is to emphasize that the lawyer's duty is not expressed as being to act in the interests of their clients, but in the best interests of their clients. We've already seen that as a relative duty, this must be assessed not only in the context of the client's wishes, but also in the context of wider obligations to the court, to the rule of law, to the interests of justice, and to the public interest itself. But it's also a qualified duty, and the word best is the qualification. It's not an injunction to identify and pursue whatever might be in the client's interests, but only in what is considered to be their best interests, taking everything else into account. Now, the law's foundational assumption is that individuals are free to make their own decisions and are capable of doing so. This view respects the capacity of someone to decide for and represent themselves, and assumes that they are competent to do so, at least until it's proved otherwise. However, where this independent capacity and competence exists, freedom of decision-making also includes the freedom to make unwise decisions. Others might say that the outcomes are not desirable for the individuals concerned, and that therefore the decision could not be in their best interests. Even so, courts and other authorities are very reluctant to interfere in these situations. Each individual effectively determines what they see as being in their best interests. There can be circumstances, though, where someone else must make decisions or act for another. And it's in these legal contexts that the notion of a best interests duty is usually created. The duty arises when decisions fall to be made, for instance, for those who lack mental capacity, as well as in cases where children's welfare is at stake. These are cases where a vulnerable individual simply cannot make decisions for themselves about their lives, their health, or their assets, because they don't have the mental capacity or developmental maturity to do so. It's also applied, for example, where directors make decisions for their company. These are all circumstances where the individual or entity concerned cannot make their own decisions, either ever or for the time being. They lack the capacity to make decisions and consequently also lack the competence to do so. So they all represent situations where a substitute decision maker is required. In some professional contexts, such as medical treatment, The professional involved might well be making decisions about treatment that the patients themselves are unable to make. They are truly making decisions for their patients or those under their care. Even here, though, it's clear from case law that the factors that the substitute decision makers must take into account are much broader than narrow technical professional expertise. That narrow focus must be extended to an assessment of broader ethical, social and moral welfare considerations that affect the person's overall well-being. And these assessments must be consistent with accepted professional practice and be made in good faith. Now, lawyers, in their capacity as advisory professionals, don't usually make decisions for their clients. So we need to draw a distinction between those professionals who do make decisions for their clients or patients as substitutes, such as doctors, and those, like lawyers, who are not substitutes, but who do nevertheless act on their client's behalf. So a lawyer not having decision-making authority then becomes an important distinction for the purposes of my analysis here. The lawyer-client relationship requires the lawyer to consult, advise, inform, and support the client in the exercise of the client's discretion, but not to exercise that discretion for the client. The distinction is important because in this third category of acting on behalf of a client, we must relate most closely to the first category, that is, of clients making decisions for themselves, rather than to the second of a substitute making decisions for them. Again, therefore, we must begin with an assumption that the client's decision-making capacity is not compromised by some lack of physical, mental, or developmental capability. But we do also, of course, have a position where a lawyer has been asked to advise that client. Rather than lacking capacity to act or decide for themselves, the client here lacks a degree of competence. That is, there's a lack of expertise and full understanding of the legal aspects of their situation. This is where regulating in some way the role of professional experts becomes particularly important. The client is potentially vulnerable to these experts, who must be trusted to apply their knowledge and expertise for the benefit of those they serve. It's not the case that an autonomous client makes every decision relevant to the lawyer-client relationship. The importance lies in the idea of the lawyer's function being to advise and support clients in making the decisions that are central to the pursuit of their interests and objectives, not to make those decisions for them. The analysis here can benefit, I believe, from looking at four important aspects of the lawyer's role in the lawyer-client relationship. And only by considering all of them can we offer a comprehensive view of what it means for lawyers to act in the best interests of their clients. So it's often said that solicitors act as agents for their clients. Any agency relationship is created by contract, under which the agent, in our case the solicitor, agrees to represent a principal, the client, in accordance with the agreed terms of that relationship. The resulting contract is often referred to as the lawyer-client retainer. As an agent, like any other agent, a lawyer is expected to display loyalty, good faith and integrity in their dealings with their client, as well as to bring independence, care and skill to the discharge of their duties. The relationship will also include respecting any confidential information shared by the client and not seeking to benefit a third party at the client's expense. However, it's also clear that solicitors perform functions that are different to most other agents, and that they are more than just agents. For instance, they're also officers of the court and members of a profession, each of which introduces other duties that are not imposed on all agents. Consequently, the general law of agency is just a starting point for analysing the legal consequences of lawyer-client relationships. There may be circumstances where the lawyer is not an agent, or does not have the full duties of a normal agent, and might even have extra duties that are not usually held by an agent at all. As a result, the terms of the agency contract and relationship might only partially define the nature or extent of what it means for the lawyer to act in the best interests of a client. Nevertheless, I'd say that one conclusion must be that if a lawyer's actions are not consistent with their agency obligations of skill, honesty, and fidelity, they cannot be said to be acting in the best interests of their clients. It's also often stated that lawyers stand in a fiduciary relationship to their clients. Their characterization as fiduciaries arises from the obligations they owe as professionals to their clients. These obligations are in fact prohibitions. Prohibitions on taking personal benefits from using property under their control, on taking opportunities for themselves that might have arisen for the client, and on taking bribes or secret profits. These commitments have been summarized judicially as the no conflict principle and the no profit principle. These obligations don't apply to all agents, hence the different role as fiduciary. The key component then is that the lawyer has undertaken to act on the client's behalf and for that client's benefit, the no conflict principle, and not for the lawyer's own benefit, the no profit principle. On this view, when the court intervenes, it's not concerned with enforcing a prescriptive undertaking to act loyally in the interests of the client, but it is concerned with the fiduciary's prescriptive undertaking not to act in their own interests. As with agency duties, therefore, fiduciary obligations only partly explain the basis on which lawyers are expected to act when representing another. However, on the basis that the fiduciary's duties lie in the no conflict and no profit principles, any breach of either of these must mean that the lawyer could not be said to be acting in the best interests of the client. As we've already seen, a lawyer is subject to a set of explicit regulatory obligations and requirements. In some cases, these repeat obligations that already exist as a result of duties arising as an agent or as a fiduciary, whether explicitly or implicitly. Hence, obligations of confidentiality, integrity, and independence are repeated as regulatory requirements in the Legal Services Act. Sometimes, though, there are regulatory duties that are not directly replicated within the obligations of an agent or fiduciary. This would be the case, for instance, in relation to the obligation to maintain proper standards of work, to the requirements of anti-money laundering compliance, or to the more specific requirements within the Solicitor's Code of Conduct relating to accounting for client money. Again, we can say that breaching any of these regulation-only requirements could not be said to be acting in the best interests of the client, in addition to those circumstances where agency and fiduciary obligations prohibit other actions. So far then, the general law of agency and fiduciary obligations and the regulatory duties imposed on lawyers do not each present a complete description of a lawyer's responsibility to their clients. Although when combined, they offer a richer description, again, in my view, it's not comprehensive. There's still something that's not included, something that we might describe as professionalism or a professional ethos. Given the multitude of different clients and circumstances in which lawyers might be called on to advise, we can probably safely assume that no set of laws or regulations can ever cover all possible ethical permutations. There will always be a gap or room for doubt. The question is whether anything can fill the gap or resolve the doubt. And would it not be preferable, in the interests of maintaining public trust and confidence in the profession, for a lawyer to act in accordance with ethical values rather than seek to use any doubt as wriggle room for questionable behaviour? While the duty to act in a client's best interests is commendable, the modern view of law as a business leads to an inherent tension between serving the interests of clients and meeting the commercial imperative of maintaining the law firm's profitability. This is starkly illustrated by this quotation. The pressures to deviate from ethical conduct in the name of making profits and bringing in business included, according to a big firm partner, inflating timesheets, undertaking unnecessary research, exaggerating the need to review everything during discovery, undertaking overzealous due diligence processes and other practices. We cheat and lie to make ends meet. We act dishonestly as a matter of course. We do it because we have no choice. If we take this as true, it's clear that organisational or cultural pressures to meet economic objectives may very well outweigh any professional obligations to put clients' interests ahead of those of the firm. It would therefore again seem reasonable to conclude that some law firm practices are unprofessional and cannot be said to be in the client's best interests. Professionalism is not the outcome of just one individual lawyer's actions. It arises from within the community in which each lawyer practices. However, as we've just seen, this can lead to and validate actions and behaviour that are negative in their client effects, as well as those that are desirable. We need to understand and address the ways in which normality becomes collectively dysfunctional, and particularly how an undesirable ethos can become normalised. This call for a more ethical approach was advocated in my 2024 report, that, as members of a public profession, lawyers' actions, behaviours and practices must also reflect an acceptance of a broader obligation to society and the public. However, too often we've seen a failure to recognise and act as members of a public profession, and a preference instead to adopt a determined but unprofessional pursuit of clients' interests or self-interest. So we should by now be clear about who the client is, who has the capacity and authority to give instructions on which the lawyer must act, and how an appreciation of the role that a lawyer is fulfilling can help us understand the basis on which they are acting on behalf of the client. Our attention must now turn to the content and substance of the best interests that are explicit or implicit in those instructions, and look at some of the challenges that a lawyer might face in carrying them out. First of all, we must be clear that it's not the lawyer's assessment that matters. Even client-centred representation doesn't focus on what the lawyer believes to be the best interests of the client. The focus should instead be on the lawyer helping the client to identify and pursue what the client believes to be in their best interests, given their wider needs, obligations, interests and concerns. The ideal starting point here would then be a client who is already clear about what they wish their lawyer to do for them, as a conscious expression of their best interests. But as we know, some clients don't know what they want and rely instead on their lawyers to tell them what they should do. Even when clients do know what they want, their view of their interests might still be considered by others to be selfish, partial or short-sighted. It's also possible that what the client wants might be unrealistic, idealistic, or misguided. In both instances, without being in control, a lawyer needs to persuade the client towards a more rational, realistic, and achievable outcome, using their knowledge and experience of the law in practice to give independent and objective professional advice. This might appear to put lawyers in a decision-making role, which would be inconsistent with their professional obligations. What the lawyer should be doing, though, is taking into account considerations that go beyond the client's narrow self-interest, and then advising the client accordingly. These considerations will include the client's wider personal, family, community, social, cultural, maybe even spiritual circumstances and values. This is also consistent with the obligation that we've already seen on substitute decision makers to go beyond narrow technical expertise and consider wider personal and social factors. So in doing this, the lawyer should be thought of as acting in the client's wider actual best interests rather than in their narrower legal best interests. But it's not always that straightforward. So a critical challenge can arise here if the client's planned actions or intentions are unlawful. The lawyer must advise accordingly because no lawyer should ever counsel their clients towards or in support of illegality. If the client is still determined to proceed, the lawyer must withdraw from the retainer. A second critical challenge would be circumstances where the client's intentions have adverse consequences and would inflict collateral damage on opponents, other third parties, or the public interest, where it might be seen, in other words, as unduly selfish or damaging to the greater good. In these contexts, we should remember that none of us is ever free to do exactly as we might wish and in what we believe to be our own best interests. The criminal law alone is testament to that proposition. Sometimes the public interest promotes a particular outcome for some beneficial purpose. At other times, it prohibits a particular outcome, say to avoid some harm. Accordingly, as I suggested in my 2024 report, lawyers should regard themselves as bound to raise wider public interest considerations as part of their duty to the client and the advice they offer. The rationale here is that confining attention to self-interest or narrow legal interests may provide only a partial understanding of what could be at stake for the client. Indeed, a material consideration is not merely to look at the client interests to be pursued, but also at the effects of the way in which they are pursued. How a lawyer conducts a particular case can have significant impacts on the client's emotional and psychological well-being, and this ought to matter to the lawyer. But these effects will also be felt by adversaries and by third parties. A scorched earth, aggressive, abusive, or rude approach to a dispute or a transaction will have effects, not just on the well-being of those on the receiving end, who might themselves be vulnerable or not represented by a lawyer, but also potentially on the reputation of the lawyer and the client. It could therefore be counterproductive and in fact operate against the client's best interests. And I should say at this point that to me there's a big difference between the robust pursuit or defence of a client's interests and steps taken to deny or obstruct someone else's legitimate pursuit of their legal rights through deliberate outspending, delaying tactics, or intimidating and misleading them. My assertion here is that the process of determining and pursuing the client's legal best interests should not be taken in isolation from the wider social and public interest. It is the role of the lawyer to encourage and facilitate this. To deny the existence, importance, or relevance of these societal factors in clients' decision-making is to claim that selfish, or at least personal and self-centered interests should take precedence over an organised, coordinated, dignified, and mutually respectful society. For lawyers to make or support such claims, when they have explicit duties to the public interest, the rule of law, and the administration of justice, would be curious to say the least. It also threatens to undermine professionalism by denying any public obligation other than to serve the client. Finally, we need to suppose that the client's quest to establish their best interests ends with something that is not illegal, but is, to the lawyer's mind, and possibly more widely, morally unacceptable, either in itself or in its consequences. An example might be extracting fossil fuels or tax avoidance. Accordingly, therefore, what should lawyers do if they face a decision in which being client-centered and acting on instructions leads to something that they think is morally wrong? This is a difficult question on which there are differing views. First, as before, the lawyer might reasonably and entirely consistently with professional obligations seek to enlighten and persuade the client that their actual best interests lie in a different direction. The lawyer is trying to coach or persuade the client to a different view of their wider best interests. Second, though, where the client insists on proceeding with their immoral intention, despite the lawyer's utmost efforts to persuade to the contrary, lawyers face perhaps their most challenging situation. The client wishes them to act on instructions to achieve an outcome that they believe is lawful but awful. We can at least be clear on this as a matter of professional ethics. If a solicitor is aware before accepting the client or the retainer, they can refuse to act. The lawyer-client relationship does not even begin. However, if the lawyer has accepted the client or matter and agreed to act, and then failed to persuade the client to act differently, the lawyer must either follow the client's instructions or withdraw from the retainer if that is possible. So, where does all this take us? Even though there's relatively little to draw on when it comes to directly guiding or reviewing whether lawyers are or have been acting in the best interests of their clients, I think it's possible to learn and extrapolate from the broad range of other professional situations that I've considered today. First, it's important to remember that acting in the best interests of clients is not an absolute duty. Second, in line with it being a relative duty, there's also a need, as they assess the legal advice that they've been called on to give, for lawyers to think more broadly about a client's actual long-term, enlightened, and non-legal interests. Third, the qualified duty to act in the best interests of a client can variously arise from a lawyer's role as agent, fiduciary, regulated practitioner, and member of a public profession. There's often considerable overlap in the duties and obligations of these roles, but it is only in the status of a member of a public profession that all of them apply. To me, this means that lawyers are never just a hired gun who must give unchallenged effect to the client's every wish, however illegal, immoral, inconsiderate, or unwise. There is a moral backstop. Fourth, and perhaps more controversially, I would suggest that the professional duty to act in a client's best interests is almost impossible to discharge as a prescriptive duty, where the clients themselves have not identified clearly what those interests are. Even where they have, it's still not a question of simply doing what they say they want. Lawyers must not turn a blind eye to anything untoward, and they must exercise purposeful curiosity about it. The duty is not therefore discharged solely by some positive mission to identify what those best interests are. It's also about understanding what outcomes, actions, and behaviours are such that negatively they could not be described as being in the client's best interests. In other words, it's as much about lawyers understanding what those best interests are not as it is about what they are, especially if there's a breach of their duties as an agent, fiduciary, regulated professional, or member of a public profession. And finally, lawyers often claim that the concept of the public interest is too broad and ill-defined to offer sufficient practical guidance. Seems to me to be rather blinkered to resist the relevance and application of the public interest to their advice and work, when their preferred notion of best interests of the client, as I hope I've shown, is itself a subordinate consideration and not straightforward. Thank you.
Thank you, Stephen, and thank you as always for such an informative and thought-provoking discussion. And thought-provoking it is indeed, because we have many questions for you. Some really great questions here to get through from our audience. So first up, can public service lawyering ever compete with lawyers wanting to make more fees or profits when ethics-backed rules have clearly been sidelined when needed?
Mhm. Yeah, that's probably another lecture in itself. Obviously there are some very public-spirited, public-facing, public service lawyers. And I have to say, in most of those cases, it is difficult for them to make the same sort of money that anybody in private practice can make. But I think if you look at both in the round, it is possible to discharge them both ethically. From what I've said, I'm probably taking a view that the more unethical behaviour tends to happen in private practice, not in public service. Uh, so maybe that's where the emphasis needs to be. But I think the question of whether you're in it to serve or to make money is part of the career decision that younger lawyers need to make. And I think, to be fair to them, increasingly are making. But there are clearly economic consequences of going one way or the other. And let's be fair, not every aspect of private practice is a road to riches either. So there's a very complex situation economically about which lawyers do what, how they do it, how much money they make, and how ethical they may or may not be perceived to be.
Thank you. Another fantastic question coming up that you might want another hour to answer. Is the phenomenon you've been describing a result of rampant capitalism, or is there some other reason for the morality crisis, especially in commercial law?
Oh, yes, that does take some unpicking. Um, I don't know that it's entirely a consequence of capitalism. I do think it has something to do with the way in which, certainly over the last 50 years, law has emerged as more of a business than a profession. And I think that's become the disconnect. In too many lawyers' minds, it's law as a business or law as a profession. My view is that it's possible to meld the two, and indeed we should seek to meld the two, and that would help address some of these issues. The other thing we've got to accept is that there's a lot of pressure from outside the profession, from big commercial clients, and indeed from ordinary citizens who really just can't afford high legal fees, to think very carefully about the economics of the business that you're running in providing legal advice and representation. So I'm not going to pretend that this is an easy dilemma to solve. I think in the interest of time, all I will say is that I don't think it's impossible to bring the two together. And that's really the challenge that I'm putting out there.
Yeah, absolutely. Thank you. Turning to in-house lawyers, if we may. In-house lawyers don't need a practicing certificate or any qualification. Are they in your licensed public profession, noting recent in-house failings?
Mm-hmm. It's a very interesting question because, of course, they may not be members of a profession at all, even though they're employed to give what can be unregulated legal advice in an organisational context. I think that, again, the short answer to that question is that I would want to apply the notion of being a public profession to anybody who provides legal advice and services for a living, whether they are actually a member of a profession or not, and whether they are actually regulated or not. I think this is about an attitude towards what you do and those you serve. And yes, it's easier to connect if you're a professional or if you're regulated, but I don't think that should be a necessary foundational starting point for behaving professionally.
Thank you. How should we address situations where legal advisors, as highlighted in the FT, conduct investigations perceived as whitewashing and against the public interest?
Well, first of all, I think you need to be clear about what the terms of reference are for those sorts of investigations. If you're initiating that sort of investigation, I think you need to be clear about what sort of lawyer you want with what mandate to carry out that investigation. But really bring it back to what I've been saying today. I think the lawyers should accept that they have a responsibility not to whitewash, not to do, in a sense, what they're being paid to do. Because as professionals, as regulated professionals, as members of a public profession, they should accept that they have these higher duties. And whitewashing is not consistent with those higher duties. What should you do about it? My short answer is professional bodies should call it out for what it is, i.e. unprofessional. And where there is a breach of regulatory obligations, the regulators should take action to say, you have not discharged your duties as a regulated person. Again, easy to say. Regulators have constrained resources. There will always be some difficulty with available evidence. There will always be some trick that can be played with the interpretation of that evidence. But to me, I think the principles are clear. Nobody should be hired or indeed paid consciously to carry out a whitewash.
Thank you. A specific question on one of the quotes in your presentation, asking where the following came from, the quote that said, "We cheat and lie to make ends meet."
I took that from an academic commentary. As I said, when I produce the working paper that I'm working on, those references will be in there.
Perfect, thank you. You said that a solicitor should withdraw where possible. Where do you foresee a solicitor being unable to withdraw from their retainer?
It's always more difficult when a solicitor is on the record in litigation. So if there are active court proceedings and then the client comes up with something that the solicitor really thinks is immoral, unwise, or whatever, in those circumstances, it can be difficult to withdraw from the retainer. So again, big topic, lots of ins and outs. We don't really have time to go into that detail, but it's not always easy.
Thank you. If a majority shareholder appoints the legal team to serve their best interests versus the best interests of the company, how can one ensure lawyers to act in the company's interests, not the individuals?
Well, first of all, I would say that a majority shareholder should not be appointing a team to act in their interests as opposed to the company as a whole. And again, we're back to the question for the lawyers: who is your client? If you're an employed corporate lawyer, your client is the company. It may be that there's a big overlap between the interests of the company and the interests of the majority shareholder. And it may be that the majority shareholder can make some decisions through special resolutions on behalf of the company. But the lawyer's got to be quite clear in any given circumstance, who am I representing? And it should never be a faction, either the board or majority shareholders, who then in effect get a preferential or a biased service from the lawyer who is not focused on the best interests of the company as a whole. And again, if you look at the Companies Act and the obligation on directors, they have an explicit statutory obligation to consider other interests, other stakeholders. And the same sort of thinking for me applies to a lawyer when acting in the best interests of the company. It's not just the narrow interests of the board or a majority shareholder or shareholders.
Thank you. A couple of questions coming up now on the post office. Do you think that enforcement action against lawyers in the post office will focus legal minds?
I very much hope it will. I mean, obviously, at the moment, we don't know what sort of enforcement action is going to be taken or against whom. So there is there's still an unknown element of what regulatory action specifically will be taken in light of what has emerged and what may emerge from the final report in the inquiry. But yes, I mean the evidence throughout that inquiry of the things that lawyers have enabled or facilitated, or in some cases even driven, does suggest that there should be regulatory action. And if that doesn't focus the minds of the profession, I'm really not sure what will.
Right. And then a question, close to both of our hearts, I think. Picking up on the work of Richard Moorhead, how should legal education address these issues, both for young lawyers and for CPD?
That's a very good question. It's also one of those, it's a bit like the TARDIS. So you look simple, but as you get into it, it becomes more difficult. If you think of legal education, we've typically got at least two aspects. We've got the academic training, which might not be law, and we've got the professional training, which will clearly be focused on, usually on admission to a particular profession. I'm always slightly nervous about the extent to which you can include professional ethics in an undergraduate law degree, and indeed from an academic point of view, whether you should even try. But it's clearly very important in relation to training for membership of a particular profession, and indeed not just at the point of qualification, but way beyond, all through your career. There should be this constant emphasis on professional ethics. I always find it quite difficult. I mean, we're dealing with lawyers who are used to looking at acts of parliament, at regulations, at codes of this and codes of that, and that should include their own professional code of conduct. There's a bit in me that thinks it's not that difficult to read a code of conduct and work out what you should or shouldn't be doing. How much training do you really need? I'm all in favour of conversations within firms, because they're all, as I said, there are always these difficult grey areas where conversations with peers or with those who are in a more senior position can be helpful and enlightening, and that should happen. But the question of formal education, I think, is the most problematic. How far can you take it when actually so much happens on the ground in the moment, in circumstances that are organizational, where clients have their own interests and bringing pressures to bear? It's those things that where I think the professional ethics rubber hits the road, and that's where people need help.
And perhaps linked to that, our final question, alas, would a general counsel and legal team see the company as their client, and could perks like a corporate jet influence their response to management misconduct?
Yeah. Well, yes, of course, the perks could influence them, but they shouldn't. The in-house legal team, particularly the general counsel, must regard the company, the organization as a whole, as their client. And they should not be swayed by any of these personal or organizational factors. That's the position. Human nature being what it is will mean that on occasion that gets shaded or even broken. And I guess the pragmatic question at that point is, do they get away with it or do they not?
Thank you, Stephen, and thank you so much for your time today and your expertise and insights in what you've clearly shown is the complexity of this challenge, and one that unfortunately we are seeing play out time and time again at the moment. I also wanted to extend a huge thanks to our audience today and for your excellent and equally thought-provoking questions, which really added a lot of depth to our discussion, and thank you for those. The recording of today's session will be available online in a few weeks, so you'll have it there to watch back again should you want to do so. But other than that, I just wanted to wish you all a very good afternoon, and thank you for your time today.
Thank you.
Thank you.